very warm hello to our lecturer Jonathan Temporal. My name is Arun Acharya and my student ID is EMB20874. Today I'm going to present about the IRAC method involved in two of our case study questions which is given to us to answer on those two questions based on IRAC method involved in those questions. Okay, I'm going to talk about the first question and my friend Sabir will continue on my questions which is the first one, and then my friend Nirmal and Abhi will continue on the next question. Okay, the first question has the issue of can George take action against Anita for the breach of contract? And the following question is, does the relationship or friendship does not make a contract? Okay, talking about contract in business, contract is formed between two or more partners. Okay, partnership between two partners is called business partnership contract, which defines the both person has agreed with the terms and condition of the business. And also written statement is more successful than and more important than the oral and handshake agreement, which basically translates to, obviously in business you need to have a contract, you need to involve your employer with the contract to work for you or to work for your boss or whatever, vice versa. And all the partners are equally responsible for binding the partnership. Of course, if there is any fault, if the company goes lost, all of the partners are responsible for that, and they basically cannot open a competing business nearby without consent of other partner, but can open a different type of business. So that basically means you cannot open a new business which is similar to your business which you're doing at the moment. That is called a breach of contract in concept of IRAC method. Okay, and partners needs to have offer between the friends to share profit and loss. That's the one rule, and they also needs to have acceptance by other partner. Basically in business, if you have partner with other members, like if you have partnership, if you're doing partnership between 4 or 5 person or one or even more than one person, there needs to have acceptance by other partner. Like if in any fault, in any bad ways, in any suggestion that you have given which could be wrong, so there has to be acceptance by other partner. Also there has to be consideration of making investment and expenses. Okay, that's all my part. Thank you very much. Next, my friend Sabir will continue with application and conclusion of this question, and there is another question which will be continued by Nirmal and Abhi. Thank you very much.
My name is Sabir Portal and my student number is OAE2030. Thank you, Jonathan sir, for giving us the opportunity to do the presentation. So, according to this scenario, the George and Anita had signed the agreement. That means the both parties have legal information to form a business. The offer had been made by one party to another, and both the party have been given their acceptance. The fact of the cases are Anita and the George and they have agreed to open the fast food restaurant. In the partnership agreement, each party right and obligation has been provided. After a year forming their business, one day with a heated agreement between Anita and George, Anita left the shop. Anita have challenged and said to George that she will open the rival business, make him out of business. Anita does the business very well. Due to the George, Anita have to suffer for the loss. So in the conclusion, it can be said that George and Anita have signed the partnership deed, and therefore their legal relation between both the parties, and both are responsible for the execution of the contract. They both are bound in the legal of deed, and if any person fail to comply with any of the terms, and other party will will ask for the confession. Anita have breaches the contract by opening a rivalry business nearby to their business. So therefore, Anita is liable to pay the remedy to judge.
Hi, my name is Abhishek Chakal and my student ID is PSI2385. I'm going to speak in the issue and the rule on the question 2. While there are 3 issues, and those are: does Anna will succeed in his claim against Michael for negligence? What is required by Anna to establish his claim for such action? And the last one is: does Michael have any defense for the claim made by Anna under civil liability? And the rule is, under the Civil Liability Act, the tort of negligence is highly depends on the recognition of the existence of the duty of care, which is owned by one person to another. The duty of care states that the one person shall have exercised proper and skill towards another person. The recognition of duty of care within the limit of law of tort shall be provided that it will be looked whether a person can take a reasonable care to avoid forcible harm to others. The claimant has the responsibility to prove that the defendant has the liability over the claimant. Then the only duty of care will be established, and the defendant will be liable to pay the damages to the claimant. In the case Very versus Wong in 2005, in this case the court has refused the appeal of plaintiff, in which plaintiff has claimed that there is no warning provided that there is risk of injury while driving the coastal waters of variable depth. Plaintiff had dived into the sea from rock platform and got injured. In this case, plaintiff agreed the defendant owned and duty of care towards the plaintiff. It was stated by court that diving into water of variable depth is dangerous, and it is both obvious and inherent, and therefore the defendant doesn't owe a duty of care towards the plaintiff. While the plaintiff claim against the drunk driving based on the negligence, the plaintiff has to prove these 4 elements, and those are: duty of care has owned by the drunk driver towards the plaintiff, the driver has breached the duty, the plaintiff has been injured in some way, and the last one is the breach by the drunk driver is cause of injury. Thank you.
Hi, my name is Nirmal Bhatrai and my student ID is YSE2009. I'm here to explain about the negligence from the given case study. According to the jurisdiction, it is easy for a plaintiff to claim about their fault under duty of care, but according to the negligence, there is no duty of care required to be proved if the injury has been happened to plaintiff by violating the public law by the defendant. In one of the case in British Columbia Supreme, it was found that a passenger, he found drunk driver, and also passenger is also contributory to the damages, and the court has reduced exactly 20% of damages paid by defendant to the plaintiff. The court found that Dickies was contributory in the negligence, and therefore on part of contributory negligence the defendant damages had been reduced. For the given case study, there are some actual facts which I'm going to tell, and they are: at the late night, Anna was waiting for taxi to take her home from her place where she worked, and Anna was too happy to take the lift from Michael than waiting for a taxi. Anna found Michael was really drinking alcohol that night, and Michael was found vehicle was not driven carefully. It was just heavily raining, so Anna preferred to go with Michael rather than just waiting for a taxi. Michael thereafter just hit the tree because he was very much intoxicated because he was just drinking alcohol. Both Michael and Anna was heavily injured. Anna claimed damages from Michael for the negligence. So they are pretty much the actual facts about the case. So just for the conclusion, it could be inferred that there is no duty of care arise towards Anna of Michael as she shows the consequence of the act. It can be said that Michael owes the duty towards Anna, but in some cases he is not liable. Anna, for establishing his care, has to prove that there was a breach of duty of care by Michael and injury has happened due to the breach. It has also been concluded that Michael, under the civil liability, can challenge the damages by taking a defense of contributory negligence by Anna. Thank you very much.